Yeah. So, hello and welcome to SocioLegalLiterary. I'm Rajesh Ranjan, founder and editor at SocioLegalLiterary. Today, in the interview series, Right to Right, Professor Sebastien Lafrance from Canada joined us. Professor Lafrance is a Crown Counsel in Canada. He is also a professor and a member of University of Haiti, Scientific Committee at University of Haiti. He has previously clerked under Honorable Justice Mary Deschamps of the Supreme Court of Canada. His array includes several important book chapters and articles on important constitutional law issues, including but not limited to judicial activism, fundamental right, linguistic diversity. He has generally attempted to draw a parallel in how a developed nation like Canada address these issues in a relationship with developing nations like India. Thank you, Professor Lafrance. It's an absolute pleasure to have you, and it's always great to talk with you. So I welcome you on behalf of Social Legal Literary to our interview series, Right to Right.
Thank,
Professor Lafrance.
thank you very much. It's always a pleasure to I'm really happy to see you this morning. I have to say, on a personal note, you guys do an amazing job. So I want to raise my hat to all of you in the organization, but more specifically to you, Rajesh, if I may say, if I may call you by your first name, very respectfully. You do a great job, so keep doing it. It's really amazing.
It's pleasure. It's my pleasure, Professor Lafrance. And I must say, all the audience who will watch this video, that Professor Lafrance, if I may respectfully say that you have been very vocal about the rights of Indians through your academic papers and lectures. G, Professor Lafrance.
Yes, no, it's because I care. I went to India, so of course we're not gonna talk about my trips to India, but I went. So I'm not, just for the people who don't know me, I'm not the kind of guy or just a Canadian guy who knows nothing about India. I don't say I know much. There's always something to learn for everybody, including for Indians themselves about their own nation, right? But I'm really interested in the law. And I've written a few pieces, comparative pieces with Indian professors on Indian law. So I really care. I'm really interested. And also, if I may say very, very quickly, because I have to do it, just a little disclaimer. Everything that I will say, because as you said, Rajesh, I'm a prosecutor in Canada. So everything that I will say is not binding on the Public Prosecution Service of Canada. Everything that will come out of my mouth is my personal opinion in my capacity. I don't know, of guest lecturer or something. I don't know, but it's not related to necessarily. It may be the same position, but it's not necessarily the same position as the Public Prosecution Service of Canada. So it's not binding on them. So it's really me this morning, and all the other lecturers as well. But yes.
Certainly, Professor Lafrance. So my first question to you, Professor Lafrance, on this note is that jurisprudence of right, when we talk about jurisprudence of right, as Doc said, a right performs a trump, and for John Rawls, if I may quote respectfully, it refers to liberty and distributive justice. Nevertheless, rights and duties are essential building blocks of modern democracy and rule of law.
Mm-hmm.
How do you see the state of fundamental right in Canada? The first part. And second part, would you agree with me that the post-COVID era will going to affect the nature of relationship between state and its citizens, especially in terms of fundamental right?
Well, I have to see what's the state of fundamental rights in Canada. So let me be positive. And about India as well. If I know we're not talking about India, but I will make connections. It goes well. Yes, Canada has problems, has legal issues. And when we say Canada, we're talking about the parliament, the legislation. More specifically, this is what interests us. Basically, the body of court, not the court, but the body that creates the laws and everything, and the way the laws interpreted has caused some headaches to and complex issues were brought to the courts, but it goes well. I mean, we do not live in a dictatorship. India does not either. India is the largest democracy in the world. Let's recall this. I know all Indians know, but not all Canadians know about this. So if there are Canadians watching this, it is important to mention. Would I agree with you? And I assume we'll come back to the charter later more specifically. But to answer your question, is it going to transform the nature, and I emphasize the nature of the relationship between the citizens and the state? Well, I will agree with you, and at the same time, I will disagree with you, and let me tell you why. And that's a very good question. Yeah. So there's always two sides to a medal, right? So it's there are two ways to answer this question. Yes, I agree, because de facto, COVID changes everything. Things were stores were shut down or closed for a certain unknown still period of time. Mobility rights were impacted in India, as you know. Sadly, there are migrant workers who had to walk hours. Some died, so it's very unfortunate. It's not unfortunate, it's tragic. Unfortunate it's more than unfortunate. It's horrible, it's very sad. And in Canada, the same. So not the same with the migrant workers, but we are also impacted from a legal standpoint by COVID, obviously, because it created itself, in and of itself, some new legal issues. It's not that we, as human beings, never experienced such a thing in the past. We did have pandemics before. The famous plagues in Europe in past centuries. A century ago, same kind of phenomenon happened. People were wearing masks and everything. So it's not totally new, but the legal system we live in evolved, sometimes changed, at least since some centuries ago, and a century ago as well. So, but the nature of the relationship, and this is where, that's the key word of the question. It's so important. It didn't. I mean, are we now without rights or fundamental rights because the nature of the relationship changed? The answer is no. Are we living in a dictatorship because we have no rights to defend? The answer is no. Yes, some people will say decisions are imposed on us, we have no decisions to make. No, but it may be true from their perspective, from a political standpoint, but from a legal standpoint, if they disagree, they can still bring motions, they can still bring cases to court to challenge it. So the relationship, to refer to the French philosopher Jean-Jacques Rousseau with the social contract. Did the social contract change? No. It is still the same type, not necessarily the exact same relationship, but the same type of relationship. So are we under a revolution or an evolution of the nature of the relationship between the state and the citizens? I would respectfully say no. But the legal issues that are raised, for example, forcing people to stay, well, not forcing, but sometimes it's not necessarily, well, at the beginning it was not necessarily forcing people, but the lockdowns, the fact that people couldn't travel anywhere they wanted because the airlines shut down, the airports shut down, the mobility inside the country itself. Canada is impacted by this. India was impacted by this as well. Was it impacted? Yeah, obviously it does change facts, but the nature itself, of the relationship. So the core, the heart of the nature, the relationship, how a citizen sees the state. So is a state a master of your entire destiny? The answer is no. And thankfulness, like goodness, my goodness, it's great, because otherwise that would be very worrying. Democracy is still healthy. People who disagree with these measures can still stand up, can still bring up motions and court and cases to court. I don't say it's necessarily the good way or the wrong way. I don't know. I'm not saying, I'm not giving my opinion about this. But what I'm saying is democracy is still alive. So that's something that is important. So the nature of the relationship didn't change, but the issues changed, and they're new. So yes.
So, Professor Lafrance, you have beautifully explained that yes, democracy is alive both in India and Canada, and you have been an avid follower of these issues both in these countries. So, I would extend our conversation in a way like talking about the difference between India and Canada in terms of right granted to them. I'm talking about fundamental right. What do you see the difference, the practical difference? Could you give any example of practical difference for general Indian masses?
Yeah, I will give you two examples actually, because I was super theoretical for the first question, really up in the sky with the theory and everything. So I'll be super practical for this answer, if I may. So I will give you two examples. The first being bail hearings, and the second, the freedom of expression, how it works in both countries. So, but even though we focus here on differences, I have to mention that we have many things that are similar. Yes, there are differences, but the first. So let's go back to the first difference. Bail hearings. Bail hearings. It is in Canada. It is constitutionalized. There are basically one section, 11E of E as an elephant, so 11E of the Canadian Charter of Rights and Freedom. That protects basically the right to bail. So people have a constitutional right to bail, as opposed to India, where it's not constitutionalized. But there's a right to bail in India as well. Okay, let's be clear. I'm not saying there is not. There is actually, and there are differences, substantial differences between the two in our two countries. For example, in India, there is the anticipatory bail that creates in and of itself legal issues. But that's a major difference. The anticipatory bail, it's a beast. It's a legal beast, said with sincere respect of India, so that India created it. It doesn't exist in Canada. And in Canada, we have the constitutional right to bail, which doesn't exist in India. So as a constitutional right, and also in Canada, for the right to bail, you do have, it is protected also as an aside, but still presumption of innocence. Section 11D is connected with the right to bail. So the reason when you go to court and if a judge asks you, well, Mr. Lafrance, is the right to bail only protected by Section 11E, I'm sorry, of the Charter of Rights? The answer is no. It does protect it directly, but also the presumption of innocence pursuant to Section 11D also protects it, because it's part of it. It's part of the idea that if people can be released, so go on bail, it's because they are not to be presumed guilty. They are to be presumed innocent. And also it is, people tend to forget about this, but in Canada, the right to bail is also protected by Section 7 of the Charter of Rights. Section 7 basically protects it's about fundamental principles of justice, fundamental justice rights. So there are in Canada these three rights. So practically speaking, somebody's arrested, he's brought to court, and he has to be released. So how is it going to work? Well, he has the right to bail usually, unless it's adjourned, but that's exceptional, but usually has to be dealt with within 24 hours. That's the standard, like be spoken to at first. Of course, there may not be a case ready to go for the bail, but usually, and the police really does a great job about this to get the job done, so the case can be spoken to properly within 24 hours in most cases. But that's the difference. It's a practical difference with India. It is constitutionalized in Canada, and it's not in India. It's mostly statutorily protected. In Canada, there are also several sections that applies. I'm referring here more specifically to Section 515 of the Criminal Code, which also addresses the right to bail. So there are practical differences with that respect. So the way it is, two things to summarize. The first is the way and how it is protected. It is constitutional in Canada. In India, it's not, but there's still rights. Okay, insist. I don't say no. There's no. It is protected, but differently. But it's not as fundamental as a fundamental right as it is in Canada. The second is the nature itself. What is comprised in what we call bail hearings, so when people can be released, it's different. So an Indian person or Indian lawyer who would go to court in Canada would basically learn a lot, and vice versa. A Canadian lawyer, actually, I never went to the court. I've seen the beautiful Supreme Court of India. It's gorgeous, honestly. From the outside, it's very impressive. It imposes respect. So does the Supreme Court of Canada. The building, so just the buildings, like you call, I don't know, there's some kind of charisma, exactly. But that would be quite interesting to see how it does unfold these things in court. So to move on, and I'll be more brief because my answer was too long. I apologize. For the freedom of expression. So there are differences. And let me point out one very practical differences. In Canada, it is protected by Section 2B, B as in bottle, 2B of the Canadian Charter of Rights. And Section 2B is the test, and that's a special, or I was going to say unusual. It's not unusual, but there's one thing that is very specific with respect to the freedom of expression. There is a requirement of harm. When you determine if there's a breach of the freedom of expression, or also called freedom of speech, but we call it freedom of expression in the Canadian Charter of Rights, it is not like the United States. Both countries are in North America, but Canada, let me recall it, we are part of the Commonwealth as India. So in many respects, we're closer to India than to the United States. People tend to not know about it, tend to forget about it if they knew it, or not know about this, but we are brothers, India and Canada. So to go back to the freedom of expression, so there is this requirement of harm. So let's say, and there's a very interesting case that the Supreme Court of Canada recently accepted to hear about the Supreme Court. It's a case of a stand-up comic in Quebec, and that's a province of Canada. He made jokes, some will say questionable jokes, about one person specifically, and the entire question of, okay, is it okay to make jokes that harsh about someone? Is that part of the freedom of expression? I'm not going to go into the content of what he said, but I believe that this stand-up comic calls it himself like dark humor. So it's not the type of humor that everybody would like, but some people do, and it's fine if they do like it. But so where does it go? Where does it end, the freedom of expression? So that will be determined. The Court of Appeal in Quebec said, no, that was too much, so that there was a breach. But what is interesting a breach of the freedom of expression. That was too much. But what is interesting to see, second point here, from a legal perspective, is the test once the court considers, let's say there's a breach of the freedom of expression pursuant to Section 2B of the Charter of Canadian Charter of Rights and Freedoms. That's not the end of the test. If there's a breach, the case must be analyzed also next to be brought under the analysis of Section 1 of the Canadian Charter of Rights. So can this breach be acceptable? And I paraphrase here, this is not the way that the Charter is. That's a very complex test that we call it the Oakes test. So OAKES. That's a three-prong analysis. It's a two-step analysis, and there are sub-criteria. It's a complex test to apply. But what you need to know is basically, can the breach be accepted in a free and democratic society? Does it make sense from that perspective? And then there's a test that applies to decide this question. So in India, the freedom of expression, it's protected by Section 19, paragraph 1A of the Indian Constitution. And the main difference here, and I will stop my answer here, but the main difference is in India, the idea, the Stuart Mill's idea, the Stuart Mill being the British thinker of a few centuries ago, but the Supreme Court of India and Cricket Association of Bengal. So this case, the court rejected the free marketplace of idea theory. So they rejected it. But in Canada, and that's I don't know. There's an article to be written about this. There are many articles published about freedom of expression, but about this very specific idea in Canada. So Canada still relies a lot on this idea of the free marketplace, but at the same time, there's this test of harm. There's this limit, but let's not forget one point subsidiarily to the idea of marketplace of ideas from Stuart Mill. So and people do not, it's forgotten sometimes. Let's not forget Stuart Mill's wrote that something along the lines that, the freedom of expression, it's fine as long as it doesn't harm other people and the people are not harmed by other people. And you see this very important word of harm. So this may be why the Supreme Court of Canada say, the marketplace of idea is okay. At least the ideas of Stuart Mills are fine, because there's this concept and limit to the freedom of expression when there's a harm that goes against the protection of other people. But in the end, Supreme Court, the highest court, as we all know, they rejected it. The Supreme Court of Canada, they didn't reject it. They use this idea. I don't say they condone the idea. They don't necessarily, but they use the idea of the free marketplace. But they, in several decisions, they wrote about this, the judges of the Supreme Court, but there is this limit of harm that clearly exists in Canadian law, so much so that it's part of the legal test to be applied when you examine the freedom of expression.
Thank you, Professor Lafrance. It's a beautiful analysis and the parallel you drawn it completely marvelous. So moving ahead, I would like to ask you, the concerns for systematic discrimination of Indigenous people in Canada is an important issue. We have been talking about through papers, newspapers, and all other issues. While Canada has officially ended it through United Nations Declaration on the Rights of Indigenous People in 2016. My question is how to implement UNIDRIP, United Nations Declaration of Indigenous People, Rights of Indigenous People, in consonance with the Constitution of Canada, Canadian Constitution. Is some of the thinkers say it's a great challenge. Certainly it's a challenge. I would like to request you to comment on this issue, that how do you think the coherence between Canadian Constitution and the idea of UNIDRIP?
Yeah, absolutely. Basically, just to recall the watchers, Canada was one of the objectors. Objector is when people are opposed to the adoption of a legal instrument at the international level. So first of all, Canada with Australia, I believe, and New Zealand, I believe, because New Zealand and Australia also have a large Aboriginal population, part of the country, part of the history of their country as well. So Canada, and so does Canada. There were two attempts, and I'm thinking my thoughts go to Romeo Saganash from the New Democratic Party. I'm not aligned politically. I'm not going to say I'm for or against this party or not, but this is someone in Canada who worked his entire life for the defense of Aboriginal rights. He is a great person. He's a great thinker as well. Sadly, he saw it in June 2019, and I will talk more about this, but that went up to the Senate. Actually, it was adopted in the House of Commons, and went up to the Senate, and then it died. So the bill, Bill C-62, if my memory does not betray me, so the bill itself died at the Senate. It didn't go forward. And what is sad is when Ms. Bennett at the United Nations announced that Canada changed its objector status, so that Canada was not opposing anymore this declaration and was actually now for it, she got a round of applause from, like, a standing ovation from the United Nations. But then it's not the end of the road. It has to be adopted in Canada. Was it adopted? Yes, it was at the House of Commons. But the process, and let's not go too much into the details because that may be boring for an Indian audience. But once an act or a law is adopted at the House of Commons, which is the Parliament of Canada, it has to go for review or analysis up to the Senate of Canada. So that's a different body. So the House of Commons, this is where, for example, you see the Prime Minister now, Justin Trudeau, and the leader of opposition. Let's just say we see this on television from time to time when they debate. So this is the House of Commons. That's the Parliament. But the Senate, it's also a different building, very close to the Parliament, but that's a different legal body. So, but the laws have also to be reviewed by them, and if they don't approve or if they don't give their stamp of approval, if I may say it very practically, it's over. And this is what happened in June 2019. The bill that was supposed to be adopted in order to implement this declaration in Canada, it died. But doesn't mean, and that's very important, especially as a Canadian, I feel bound, I feel the responsibility to also show the other side of the medal. Yes, it's very unfortunate that this bill didn't go through, but at the same time, does it mean, and mostly the reasons why, it's basically because the Conservative Party members and senators said, well, the legal impact and the economic consequences are very harsh for Canada, so we are opposed to this. Not saying they're opposed to Aboriginal rights, let's be clear, okay? It doesn't mean they're opposed to it, but they said because of that's the Conservative Party is the opposition party right now in Canada. So they said the legal consequences are too broad, and the economic consequences are too serious. So no, we're opposed to it. So, but doesn't mean that Aboriginal people have no rights in Canada. Well, no, absolutely not. There is there's more than Section 35, but there is Section 35 of the Constitution, and the Ambassador Bennett at the United Nations, well, she's right. For sure, at least about this. She said that Canada has a robust framework for the protection of indigenous rights for the Aboriginal population. So it is constitutionalized, right? So it's a fundamental right for Aboriginal people. They have protections of their treaty rights pursuant to Section 35. Also, from a criminal law standpoint, I can never forget about this because I'm a prosecutor, but there's also these two very important decisions of the Supreme Court of Canada in Gladue, Gladue, and IPLE, IPEELEE. So these are two very important decisions that basically it applies at the bail stage, but mostly at the sentencing hearing stage. So it says that not for the most serious offenses like murders and horrible criminal cases, but for the other cases, not necessarily not serious, but for more standard cases than murder cases, they say it differently in more legal terms. Of course, that's the Supreme Court of Canada. But what they say is that the sentence that must be imposed on the Aboriginal population, so on the indigenous population, has to be mitigated. And this is not the same standard that applies. It has to be more lenient. Why? Because of the historical background of the Aboriginal population and the trauma suffered by the Aboriginal population. As a side note, and I will get back to the United Nations Declaration, but as a side note, jails in Canada are overcrowded by Aboriginal populations. So this is something that was taken by the Supreme Court of Canada took a judicial notice of it, basically, and said, well, yeah, that's overcrowded, so there's something going on, and why? So basically, the Supreme Court of Canada judges turned their mind to it and rendered these two decisions they're not together.
How diversity.
I'm sorry?
Yes, Professor Lafrance. This shows how diverse Canadian society is.
Yeah, exactly. So all of which to say doesn't, like, the fact that the United Nations Declaration pertaining to Aboriginal people that was not implemented in Canada, so doesn't mean they have no rights. No, it doesn't mean that they had in Canada. But of course, and let me recall briefly, if I may, so what this United Nations Declaration provides, and of course I'm not going to read to you the entire declaration, but let's keep in mind there's Section 26 that provides that the Aboriginal population of the Declaration, so we're out of the Canadian Charter of Rights, we're back to the United Nations Declaration. So Article 26 of that declaration provides that there's a right to have a return of the land. So that if their land claims, they would have the right to get it. Doesn't mean in Canada they never do. No, it's not. But there's a plenty of land claim cases in court. So they claim this and that territory inside the perimeter of the sovereignty of Canada. Okay, so but that exists already, and that's been done. There are many cases that went up to the Supreme Court about this. We're not going to talk about this morning, but still, there's a specific provision about that. So there's also reparation. So reparation, what does it mean? That's provided by section from 26 to 30 and section Article 32 of that United Nations Declaration. So reparation means what? It may mean, most of the time it means money. So basically, that provides for financial compensation for XYZ. Does it mean it doesn't exist in Canada? No, it does not. Like there are cases in the past that went to court or that were negotiated, didn't go to court, but were negotiated by provincial governments, or in Quebec, I'm thinking of, there's one event in particular, or it has to be dealt with and approved by the federal government, because federal government has the say about this. But it exists, but it's not as it is so broadly protected in that United Nations declarations. Also, and that's something else, and I may take some time about this. I apologize in advance because I'm talking too much always, but please let me give me 5 minutes about this. It's very important. So if you look at articles from 9 to 15, Article 16, Article 25, and 30, Article 31 of that United Nations declarations, basically what it covers summarily, it does protect the culture of the Aboriginal people, the practices, the languages, and education. So let's stop a moment. So that's why I did ask for, give me 5 minutes. But let's talk briefly about the language rights and education rights. Because these things are protect, the language rights there are two official languages in Canada, and there's also two other very important section of the Canadian Charter of Rights and Freedom about education. This is section 23 of the Charter of Rights, and there's also section 27 that speaks to multiculturalism. But I will make a connection here with the Aboriginal population. So multiculturalism in Canada, there's an act about multiculturalism, but it's also constitutionally protected. But the way there are many ways to interpret it. So is it a substantial right or a right that is used to interpret the law? Well, there were debates about this in the doctrine and among the academics, and who wrote a lot about this. So what does it mean, multiculturalism, I'm sorry, being constitutionally protected? Well, the last say on this is that, and the court has written about this, but not about this specific issue, but has used it, this section of the Charter of Rights, it is used to interpret the law. So it's still somehow limited. So basically, practically speaking, it has to be in the back of the mind of the decision makers that Canada is a multicultural country. India is also obviously a multicultural country. I'm not going to teach you anything here. So we are brothers. India and Canada, we are a family, a legal family at the very least. So when we go back to the Aboriginal population, and there's a distinction, because in Canada, yes, multiculturalism is protected, but there are still only two official languages, French and English. And English and French, if you want to put English first, I probably said French first because I'm a French speaker. Originally, I'm trying to, but one or the other, there are official languages. So what is important to know, multiculturalism doesn't make you have the right, if you would claim, and there's a case the case of Nguyen that went up to the Supreme Court. So is there a protection to have schools in your own language necessarily, or to basically claim a Charter of Rights, Section 23, to have education, have a school board that speaks Hindi, let's say, or Punjabi, or another language in Canada? No. Well, there are schools, and somebody would tell me, well, Seb, you don't know what you're talking about, because I know there is, for example, an Armenian schools where Armenian is spoken, and etc. No, of course, yeah, it's fine. It's not what I'm saying. What I'm saying is there a constitutional protection for this? And in those schools, there must be a prevalence of one of the two official languages. So we are still in Canada. So, but there's this clash, and that's a longer debate. I don't give a detailed analysis of this. I would like to, but I know we don't have several hours. But that's a very interesting issue. I co-wrote for those who
we can perhaps talk later.
Yeah. And for those, if I may, Rajesh, very briefly, for those who would be interested, there will be a book chapter that Professor Shruti Bedi and myself, we co-wrote this about linguistic rights in India and Canada. So for those who are interested, it's not published yet, but that will be published next year. So for those who are interested, let me know and I will tell you when it's published. Focus on linguistic minorities' rights in India and Canada. So, but to go back briefly, to wrap it up in less than 1 minute, about Aboriginal rights. So protecting cultural rights, what does it mean also, going back to the United Nations declarations? Well, it's all the rights, rights, R-I-T-E-S, and not the rights as in constitutional rights, but rights and practices that are protected. And there's a fuzzy or a blurry tension that would exist with the idea of the protection of multiculturalism, because multiculturalism, as I said initially, it doesn't protect everything. It does, so it is limited. So there's this clash, there's this legal clash also that exists. So is there a solution, to answer your question? Is there a solution? Well, I don't know. It's in the hands of the legislation and the Senate and the Parliament. I cannot say it, but I think to answer the question, practically speaking, it was important to say that, yes, it didn't work out. I don't say it's not sad, especially for Mr. Saganash, who worked so hard on this. I don't say it will not happen again, that Canada will try to adopt in the first place, and second, to implement this United Nations declaration, especially that Canada gave its okay to it. So Canada is now in favor of this declaration and is for this declaration. So, but there's another question. We'll leave it for another time. But this tension that also exists between domestic law and international law. So international law in Canada has to be like, there are various theories, not theories, but various ways of enacting it. But let's leave it for another day. I could speak about it, but
it's again a debatable issue, the confrontation between domestic law and international law, Professor Lafrance. Perhaps we can do a separate interview for this.
Yeah. Thank you.
So I would like to take you back the issue of fundamental rights in Canada, Professor Lafrance.
Yeah.
And for a general Indian audience, Professor Lafrance, and you have been following us also very closely, I would like to say, what does it mean to be Canadian Charter of Rights and Freedom? Just quickly tell us about, for our viewers, about its applicability and what it means to be for Canadians and why Indians should engage with it.
Yeah. I'll be very quick on this one, just to compensate for my wordiness for the other questions. But just to say, this question alone could easily take hours, but I will wrap it up in a few minutes. So the Canadian Charter of Rights was enacted in 1982. Before, we did have the Canadian Bill of Rights, but it didn't have the same scope as the Canadian Charter of Rights does. It not the same application as well. So Section 32 of the Canadian Charter of Rights answers directly your question. So to whom does the Charter apply? So the Charter apply basically to government action and to the legislation. So what does it mean? So basically, practically speaking, it applies to the laws. So again, the laws that are adopted by the Parliament, which is a different body than the courts, right? And the executive, so that's separated. So are the laws adopted constitutional? And summarily, what kind of rights are protected? And again, India and Canada are very close. The same rights do exist in India, and some bad tongue would say, well, Seb, it exists everywhere. No, it doesn't. So I'm sorry. There are countries where these rights do not exist as constitutionally protected rights. There's most of the fundamental rights in Canada are protected by section from 2 to 7, and there's section 15. So summarily, section 2 as the freedom of religion, the freedom of expression, the freedom of association. So that's respectively section 2A, 2B, and 2D. There's also Section 7 that I mentioned earlier about the fundamental principles of justice, which is a more, I was going to say, but I know some constitutional lawyer would say, Seb, you're totally wrong, but summarily speaking, it's an all-encompassing section. It doesn't, all-encompassing means it does apply to everything. No, it's not. And I'm thinking about a case of the Supreme Court here, but let's discuss it summarily. So basically, it's the principle that is all-encompassing. It doesn't mean it applies to everything, but fundamentals of justice, like the fundamental principles of justice. There's a section, the presumption of innocence I mentioned earlier, the right to bail, so section 11D and E respectively. There's also section 15, very, very, very important section, especially for Indians here, about that's the equality rights. So in Canada, section, and I know a prof who wrote an entire book about section 15. He did his PhD thesis about this, only about section 15. And there's easily, of course, writing a thesis, it's never easy, but there's a lot of stuff to write about, a lot of material. So basically, discrimination in Canada, and there are legal tests that applies that we'll not talk this morning, but equality rights is given. There shall not be gender discrimination, racial discrimination. So here, this is where we talk about the connection with Indians. So if the government adopts a law, let's say, oh, Indians are this or that, and they shouldn't be allowed in the Canadian territory, or that's an extra, the Parliament will never do that in the shape and form that the government is now, or we live in a democracy. But I'm just giving you an example, an extreme example of a law. So this law would go against the Charter of Rights. So Indians are forbidden in Canada because Indians are too smart, and we don't want them in Canada because we want to protect our people, and no Indians in Canada for that reason. So be geniuses in India, but please don't come to our country. We'll look stupid. And I'm joking. I love Canadians as well. I'm a Canadian, proud Canadian, just an example. So this law would probably be found unconstitutional based on Section 15 because it does protect equality rights and against racial discrimination. It does protect also sexual orientation there's a famous decision in Vriend, V-R-I-E-N-D, decision of the Supreme Court of Canada. So it does protect equality rights for various groups of people. So there is a list, but the list is not exhaustive. And this is why I mentioned this decision of Vriend. So there is this constitutional law way of it's called the reading in. So we can read in Section 15. Of course, it has to be claimed. It's not like you can claim whatever equality rights. There's a test that applies, and it's been addressed by the Supreme Court of Canada, but let's just say that it's not limitative and exhaustive. So when you look at Section 15, does it mean that all the equality rights are there and that's the end of the story? No, it's not. So it does not protect actually directly. I said it does. Let me correct myself. It does not protect directly sexual orientation, but it doesn't say it. But that's based on the process of the reading in. It does protect it. So sorry, but there's a section in the provincial Charter of Rights that directly addresses it. But at the national level, the answer is no. So yes. Does it apply to non-citizens? The answer is yes. Let's say there are Indians who immigrate to Canada. Are they protected by, and they're not immigrants yet? Does it mean that there is absolutely no, they're not Canadians yet? Does it mean they have no protection under the Charter of Rights? The answer is no, they are protected because of the immigration laws. And basically the notions are of citizenship. These are concepts and notions that are related. So basically because immigration law regulates the legal admission to Canada, immigration laws apply to non-citizens So the charter applies to this law, applies to those cases. So there's a chart. So there are several cases, immigration law cases, where the Canadian Charter of Rights and Freedoms is raised. So that could apply also to Indian. Also, and I must say, we're talking about immigrants, we're talking about Indians as non-citizens. And of course, I have to mention, I have a few very good friends in Canada who are Indians, who have Indian backgrounds, but there is also a big population of Indian Canadians. So, and many of them are born in Canada. So I'm not, when we talk about Indians, we also talk about Indian Canadians. So Canada is a rich, diverse country with a substantial Indian population. So I just wanted to say that. So we are, oh yeah, there is no, why would I go to Canada? Well, there is a big Indian population here. So both Indian Canadians are protected, obviously, by the Canadian Charter of Rights, by the fact that they are Canadians, but also, and I wrap it up here, but also, sorry, the Indians who immigrate to Canada by way of the application of immigration laws where the Canadian Charter of Rights and Freedoms applies.
That's the beauty of your answer, Professor Lafrance. You have ability to answer the questions in a humorous way. So with this note, as you said, our society, Canadian society is multilingual, diverse. So where do you place the issue of women's right in Canada? And there has been numerous occasions when the issue of violence against women and the discrimination has been reported. How should the multilingual society, or let's say diverse society or democracy like Canada, should tackle this?
Yeah. First of all, very briefly.
Professor Lafrance, just 1 second.
Yes.
Just 1 second. I would like to ask from technical members. I have been logged down. Is that any affect our previous recording? Rebecca?
No. Yeah, so you're not audible. Like your voice is cracking a bit, and your video is also stopping in between.
मैं ये पूछ रहा हूँ कि अभी मैं लॉग आउट हो गया था तो क्या उसका कुछ अफेक्ट पड़ा प्रीवियस रिकॉर्डिंग पे?
No, not really. It is continuing.
Okay, perfect.
Yeah.
Well, if you want to cut me out and answer the question, that's wonderful.
For once, so.
No. No, Professor Lafrance. Just
no, I'm joking.
We will edit this. Before putting on the YouTube, we will surely edit this because I just noticed that I have been logged out in between. So yes. I was just checking out, is that affect our previous recording or is it okay? So this
No, for sure. No, I understand because I saw you and I was checking when I was answering if you were still there. You were still there, so I didn't stop, but it lasted maybe 1 or 2 minutes. So it's but the technical support will do magic. So thank you. I know I don't see you now because you're too shy to show yourselves, but thanks to to the technical team here.
That's the art of background magic.
Yes, it is. Indeed.
Yes, Professor Lafrance. We were talking about the issue of women's rights in Canada.
Yes.
There has been numerous occasions when the issue of violence against women and the discrimination has been reported. How the multilingual and diverse society like Canada should tackle this?
First of all, very recently, Prime Minister Justin Trudeau he promised to give millions of dollars to support women's shelters and sexual assault centers in Canada. So that's something. And as a preamble, women have a prominent role in Canada. Not saying they don't in India, but we're focused more on Canada with this question here. But they do have a prominent role. I would like to raise my hand, but it's like I'm actually must bow before the Right Honorable Beverly McLaughlin, who was the first Chief Justice of the Supreme Court of Canada. Now it's the Honorable Mr. Wagner is the Chief Justice of Canada, but Justice McLaughlin was the Chief Justice of Canada for many years, the longest period of time in the Canadian history, and that was a woman. She was out of this world, phenomenal. I had the chance when I was clerking there, and I also had the chance to have several interactions with her when I worked at the law branch of the Supreme Court of Canada, also after my clerkship. She's quite the lady, said with the utmost sincere respect. In the legal area, women also are, let's say, more than 50% of the law students are women nowadays. So how can we reconcile women's rights with the fact that Canada is a multicultural, multilingual, as you wisely said, Rajesh, society? There's one example. Let me give you a practical example. When I was in Nunavut, and we'll go back to Aboriginal population briefly, but in light of women's rights, because I have this, when I started as a Crown, I had to apply the Gladue and Ipili principle that I mentioned earlier in criminal law, which basically calls for mitigating sentences because of the background of the Aboriginal population. But what about domestic assaults? What about when a man, most of the times, but I had cases where men were assaulted by women. I did have cases like those. One very serious, but most of the time it's women who are assaulted by men, physically assaulted. I don't want to go into the details, but we all know what that means. So violence, basically. When we go to the sentencing stage, so what sentence should be or must be imposed? What sentence is fit to a man who violently assaulted is women? So we have this Gladue Ipili principle that tell us, well, you have to mitigate and make sure you take into consideration the factors of the background of the person. But when the woman is also an Aboriginal person or Inuit person, as in Nunavut, what happens? So there's some kind of, so yes, there will be a more lenient sentence imposed on the man. But what about the woman? She's also Aboriginal Inuit, and she suffered the violence, and then she sees, and I give credit to this to, I'm not going to say her name out of respect, but this is something that when I started as a Crown several years ago, but as a prosecutor, a lady was working in our office who was Inuit. She told me that. I said, well, that's good that Aboriginal and Inuit people get more lenient and sentences, not for the most serious offenses. Okay, I'm totally for it because of our background, but I'm a woman, and if I see a man given a more lenient sentence just because of his background, I'm offended. So there's something that comes into play here that clashes, which is, okay, we have these group protection or a group principle, the group idea where the Aboriginal population is not protected, but is given a special not treatment. I don't like this word. It's like it has a positive connotation, which it doesn't have here because we're talking about serious stuff, sentencing. But they do have they're in a special category of people for their own sake. But at the same time, when you look at the individuals, the women who suffered, who come from the same background, like there's something that does not reconcile. There's a problem here. Of course, it's been addressed by the courts. Of course, for the most serious cases, these principles, in the case of murder, for example, an Aboriginal person will not be given will not enter into this special category. So for the extremely serious, to use the terminology of the court, the extremely serious cases involving violence, murder cases, of course, these principles of mitigation or of giving a more lenient sentence do not apply. But still, this is not there are not murder cases every day in court, and there are many, many domestic assaults. I'm fully aware, by the way, I'm fully aware of this issue in India. It was rightfully covered in the media.
It's equally pathetic, Professor Lafrance. It's just disturbing that the cases of domestic violence has rising in such a pandemic time.
Yes.
That the reports are coming, and they just look at how shameful in for us in 21st century. Like when we talk about the progress society, the idea of transformative society,
Mm-hmm.
it looks very bad as a society for us.
Yes. Yes. And there's this thing too. Maybe the technical support should, because I'll wait, because Rajesh, the picture is now frozen, so I just want to make sure we're still
Right, sir. His video is hanged.
okay.
I am audible.
You're audible, sir, but your video has hanged.
Can I log out and log in?
Yes,
All right,
yes.
sir.
Yes,
We'll
sure.
stop the recording for the meanwhile then.
Okay.
Yeah, you're audible, sir.
I am really sorry, Professor Lafrance.
No. Don't be. No, it's fine. Honestly, it's fine. It's all good. It happens, and actually, as a side note, we have this technical means that allows us Indians and Canadians to connect. We have this means, technological means that allow us to. So that's great.
It's great, but I am here in countryside area of India, and the network connectivity is very poor. I'm trying to, like, for every event, I am trying to reconnect it, but this is very poor.
Oh yeah, but it still works pretty well so far. So it's don't like I said, it's zero concern about this. It's all good. Absolutely no worries. So maybe we can. You want me to just? I can go back to what maybe you want to ask your question again. I don't know. I'm really in your hands.
Rebecca, has previous things have been already recorded, or we just initiate the fifth question again?
Everything is being recorded. We'll do the editing work of it. But meanwhile, I had paused when you were logged out. So I'm continuing again.
Okay, no problem.
Okay.
So we should just wrap up this conversation, and I will ask some casual questions that how do you think, what your message to Indian law student in all these questions, the casual conversations, just in 5 minutes, and we will wrap up.
Yeah, sure. So you want me to speak to, like, talk to law students in India? Is that it? Like it as open message, basically?
Yeah, sort of open message. So I will just prepare a background and
okay.
So thank you, Professor Lafrance, for this candid conversations on very important issues, ranging from fundamental right to the women right issues, and drawing a parallel between India and Canada. Just in quick 5 minutes, as we talked also previously, that how you cherish the togetherness of India and Canadian values, and you have been very a prominent face among Indian students also, like the students from NLU Jodhpur, the college from where I belongs. They have been also following you. So what's the message for them? What do you think that how should go for a better world, for a better society as such?
Well, I never think you're alone. Never think I'm talking to the younger law students or the young law students. Never think you're alone. Never think that you will not make a difference, because India, as we all know, has a population of 1 billion people. You are important. As I said earlier, India is the largest democracy. It is worth to be fought for. It is worth to be defended, and your voice shall be heard. And you have an important role as law students and future lawyers and future academics to keep that in mind. India is at the forefront of democracy in the world, and it must be protected. So Indian law students not only have the responsibility of defending democracy, the rights and freedoms for themselves as Indians, but I will go as far as saying that you have this responsibility for the entire human race. And so do Canadians. But Canadians are 35 million people. You are more than 1 billion. And there are way more many law students in India. Stay on guard and remain hopeful. There is a future, especially to those who may be desperate sometimes. I was desperate sometimes in my law studies. It's so much worth to work hard, but don't think only about yourself. When you miss motivation and you lack hope, and so you lack motivation and you don't know what to do, think about this. You just don't do it see it as a mission. Even though you work in whatever field you want to work in, corporate law, commercial law, criminal law, competition law, whatever law it is, see it as a mission. Not only see it as your studies. It is not a banal or just a boring area to study. If you're not passionate, talk to friends, watch webinars like those. Or from, not necessarily with me, like, I don't care, watch webinars, do something. I'm not making advertisement for myself, but
But certainly, Professor Lafrance, on a serious note, these things help. In fact, today I was watching a webinar from Live Law.
Thank you so much. But my message is, you are important as a group and as individuals. And of course, you have a rich culture, a diverse culture, a diverse community, various languages. There's so much to say about India, about Indians, but stay focused. And this is not a time where democracy can be taken for granted. This is not a time where Indians have, maybe they never were, but this is not a case where Indians may be just one of the players. Indians are major players on this planet for various reasons that I mentioned, and there are more reasons to be mentioned. So don't take this lightly. It shouldn't be, shall not be. But also, out of this, get yourself inspired with passion, with dedication, with motivation, with hard work put into your efforts to accomplish. And there's no simple tasks. There's nothing as such as, oh, well, I'm just this person, this student. It won't make a difference. Don't forget about the butterfly effect, the domino effect, or whatever effect you want to put a picture with alongside. You make a difference. Believe in yourself, actually. That's what I would say. Believe in yourself. Believe in the world as it should be. Democratic, free of dictatorship, free. Look forward to a future, an ideal future to all human beings. And yourself, Indians, put yourself into this world with this mindset. And I wish you sincerely all the best, but not all the best. We don't know what is going to happen. Like, fight for yourself, fight for the rights and freedoms. And sometimes, whichever position, and it may be, because I'm a prosecutor, somebody may say, well, what is he saying? He's putting people in jail. That's how I was told we are perceived in some parts of Canada. Yeah, but Crown prosecutors have a duty to have justice rendered by the courts. So we are on the side of justice. Sometimes it means that we have to ask for jail sentences, but it doesn't mean that we don't care about the Charter of Rights. We care a lot, and we take it into consideration a lot about fundamental rights. And we have as a duty to take these rights and freedoms into considerations in all of our cases. Not saying that it will make everybody happy, maybe not, but we do take all these into consideration. And there are fundamental rights, similar, in many cases, identical fundamental rights in India. Yes, they may have been interpreted differently, different legal tests apply, the scope of these rights are different, but the core, the democratic core is the same. So believe in yourself, believe in freedom, believe in rights and freedom, and just don't think you're alone. And I'm saying this especially in this time of isolation where people are, and you were mentioning yourself earlier, Rajesh, that you're in your apartment in the country house. Well, you know you're not alone. Nobody's alone, and I'm not saying that because you said you're alone, but I'm just taking you as an example, if I may say.
No, I said I am in countryside.
Yeah, you have all the beautiful nature around you, but but because of this time of isolation, it is important to be recalled and reminded to everybody that no, beyond this connection of the technological means, we have all these things that I mentioned that still do exist. And there is an end to this nightmare. We don't know when it will happen, but there is an end to this pandemic. So let's keep faith.
Certainly a great message from Professor Sebastien Lafrance. And I would like to thank you, Professor Lafrance, for this wonderful morning and your morning and our evening.
Yes.
So this is very great, and thanks to this means that we have contacted. So this means, so thanks to technology also, and thanks to you as well for taking this initiative to talk to us and be courageous enough to talk to us on different issues and give a beautiful message on a very personal note to Indian law students. So thank you, Professor Lafrance. Thank you for joining us, and thanks you, the SocioLegalLiterary technical team, for sparing out the time to facilitate this discussion between me and Professor Lafrance. And on a very personal note from SocioLegalLiterary, when you come to India, please meet us.
Absolutely, I will. It was sincerely a pleasure to be with you this morning and to talk to you about these issues, and I'll happily come back to speak to different issues in the future. And I will certainly, next time I go to India, I will do my best to, for sure, stop by and say hello at the very least. Of course.
We would love to host you, Professor Lafrance. We would love to host you. It's always a pleasure to talk, Professor Lafrance. So with this note, we end this discussion. Thank you, Professor Lafrance.
Thank you very much.